work to do on this. I want to get into judicial activism. I brought this up in my opening statement. As I see it, there's kind of an impoverishment of our political discourse when it comes to the judiciary. I'm talking in politics. When candidates or office holders talk about what kind of judge they want, it's very often just reduced to, I don't want an activist judge. I don't want a judge that's going to legislate. And that's sort of it. That's it. It's a 30-second soundbite. As I and a couple of other senators mentioned during our opening statements, judicial activism has become a code word for judges that you don't agree with. Judge, what is your definition of judicial activism?
It's not a term I use. I don't use the term because I don't describe the work that judges do in that way. I assume the good faith of judges in their approach to the law, which is that each one of us is attempting to interpret the law according to principles of statutory construction and other guiding legal principles, and to come in good faith to an outcome that we believe is directed by law. When I say we believe, hopefully if we all go through the process of reasoning it out and coming to a conclusion in accordance with the principles of law. I think you're right that one of the problems with this process is that people think of activism as the wrong conclusion in light of policy. But hopefully judges, and I know that I don't approach judging in this way at all, are not imposing policy choices or their views of the world or their views of how things should be done. That would be judicial activism in my sense if a judge was doing something improper like that. But I don't use that word because that's something different than what I consider to be the process of judging, which is each judge coming to each situation trying to figure out what the law means, applying it to the particular fact before that judge.
Okay, you don't use that word or that phrase, but in political discourse about the role of the judiciary, that's almost the only phrase that's ever used. And I think that there's been an ominous increase in what I consider judicial activism of late, and I want to ask you about a few cases and see if you can shed some light on this for us and for the people watching at home or in the office. I want to talk about Northwest Austin Utility, District Number 1 v. Holder, the recent Voting Rights Act case, and Senator Cardin mentioned it, but he didn't get out his pocket constitution, as I am. The 15th Amendment was passed after the Civil War. It specifically gave Congress the authority to pass laws to protect all citizens' right to vote. And it said, Section 1, Amendment number 15, Section 1, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2, this one's important. The Congress shall have power to enforce this article by appropriate legislation. The Congress. Well, Congress used that power, the power vested in under Section 2, when it passed the Voting Rights Act of 1965. Now, the Voting Rights Act has a especially strong provision, Section 5, that requires states with a history of discrimination to get pre-approval from the Justice Department on any changes that they make in their voting regulations. Congress has reauthorized this 4 times as recently as, last time was 2006, and the Senate supported it by a vote of 98-0. Every single senator from a state covered by Section 5 voted to reauthorize it. So now it's 2009, and we have this case, Northwest Austin Utility District Number 1. And Justice Thomas votes to hold Section 5 unconstitutional. He said it went beyond the mandate of the 15th Amendment because it wasn't necessary anymore. That's what he said. Now, when I read the 15th Amendment, it doesn't contain any limits on Congress's power. It just says that we have it. It doesn't say if necessary, the Congress shall have power to enforce this article. It just says that we have the power. So it is my understanding that the 15th Amendment contains a very strong, very explicit, and unambiguous grant of power to the Congress, and because of that, the courts should pay greater deference to it. And my question is that your view?
As you know, some of the justices in that recent decision expressed the view that court should take up the constitutionality of the Voting Rights Act and review of its continuing necessity. Justice Thomas expressed his view. That very question, given the decision and the fact that it left that issue open, is a very clear indication that that's a question that the courts are going to be addressing. If not immediately the Supreme Court, certainly the lower courts. And so expressing a view, agreeing with one person in that decision or another, would suggest that I have made a prejudgment on this question.
So that means you're not going to tell us. I didn't mean to finish your sentence. I think I knew where you're going.
All I can say to you is I have one decision among many, but one decision on the Voting Rights Act and not the recent reauthorization by Congress, but a prior amendment where I suggested that these issues of changes in the Voting Rights Act should be left to Congress in the first instance. My jurisprudence shows the degree to which I give deference to Congress's findings, whether in a particular situation that compels or doesn't or leads to a particular result, is not something that I can opine on because particularly the issue you're addressing right now is likely to be considered by the courts. The ABA rule says no judge should make comments on the merits of any pending or impending case. And this clearly would be an impending case.
Okay. But it's fair to say, though, in your own decision, you gave deference to Congress, just like you answered my net neutrality thing saying it's up to Congress. Well, it feels like this is very explicitly up to Congress.
I gave deference to the exact language that Congress had used in the Voting Rights Act and how it applied to a challenge in that case.
Okay.